Now, thank you all for being here today. And my name is Jan Flagel, and I'm an Associate Director in the HR Advisory and Consulting Division of Forvis Mazars, Australia. Before we start this webinar, next slide, please. We acknowledge the traditional custodians of the lands on which we virtually meet today. We pay our respects to the elders past and present, and extend this acknowledgement to all Indigenous peoples here in respect of their cultural connection to country. Now, please remember that this presentation is general in nature and is delivered for information purposes only. Please do not rely on the information provided to address your personal circumstances, but consult with professionals to seek advice, which can include us if you wish to do so. We have expert audit, accounting, taxation, payroll, and of course, HR advisors who can assist you if required. Also, please make sure that your microphones are turned off if it's not already done for you. We will also have some Q&A time at the end of the session. Please enter your questions by clicking on the Q&A button, which is located right at the top of your screen. Now, you may have missed out on our last HR Sunrise series session, during which we covered each of the topics that I will summarize today. My aim today is to give you 4 key takeaways from each of the sessions relating to sexual harassment, psychological safety, hybrid working, and underpayments. Let's get started with a big one: sexual harassment in connection with work. What is interesting is that often people ask me at training sessions how they need to respond when it's not a very serious sexual harassment incident, but more like a little joke or a comment that people did not mean to actually give. And I always have the same answer. It does not matter how subtle or severe or how harmful the behavior is. Sexual harassment is sexual harassment. If it meets the sexual harassment test, which we're going to talk about later, you need to address it. And you need to have a zero tolerance approach about it. However, it's not the hammer on the fly all the time, because it's not about the severity of the consequences. It's about the certainty that there will be consequences if an employee does the wrong. That's what really matters. Now, the definition of sexual harassment, it's very straightforward. Sexual harassment is defined as an unwelcome sexual advance, unwelcome request for sexual favors, or other unwelcome conduct of a sexual nature in circumstances where a reasonable person, having regard to all the circumstances, would anticipate the possibility that the person harassed would be offended, humiliated, or intimidated. Now, that is very simple. It's unwelcome, it's of sexual nature, and the person, the perpetrator, they ought to know that. Just don't go there. Just don't do that. You should not do this. The test, yes, 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 it is sexual harassment, and it doesn't matter how severe or subtle it is. But remember, a one-off incident may constitute sexual harassment. Now, it talks about sexual harassment in connections with work. The law prohibits sexual harassment that occurs in connection with work. So what it means is that, and what is really important for you to understand is that for the purpose of sexual harassment law, definition of work, workplace, and connected with employment extend way beyond traditional office worksite settings. A workplace is a place where work is carried out, but it also includes any place where a worker goes or is likely to be while at work or in connection with his employment or their employment. Employers can be held vicariously liable for discrimination and harassment that occurs in the workplace or in connection with a person's employment, including at employer-sponsored events such as seminars, conferences, training, or workshop, work-related social functions such as the infamous Christmas party, We've all heard of the stories there. Business trips or field trips. The common areas, such as the lifts, the entrances, reception areas, the corridors, the kitchen, the facilities. Working remotely, virtually, from home or from any other location. But also the transportation, the cars, the buses, the ship, planes, and accommodation arrangements. When workers are traveling for work, we'll actually talk about a particular court case that refers to this later. Employers can also be liable when computers, phones, tablets are used to harass a person, for example, by sending text messages, posting on social media sites, or sending emails that have a connection to the workplace. Now, what is the context in Australia? Well, it's not a great context, to be honest. According to the Sexual Harassment National Inquiry report that was run by Commissioner Jenkins and her team, almost 2 in 5 women, that's 39%, and just over 1 in 4 men, that's 26%, have experienced sexual harassment in the workplace in the last 5 years. The same survey found that 85% of women and 71% of men who experienced sexual harassment in the workplace did not make a formal report or a complaint. So what is important here is, as an employer, you must actively anticipate, work out what are the barriers so that you can lift these barriers. Sometimes people just don't know where to go. They don't know where to access the policies. They don't know what rules. Is there a complaints and grievance procedure policy here? What is the process when I want to complain? Simple things like that. What is important for you to know is that the Fair Work Commission, for instance, if an employee calls Fair Work, and I've had this case many times when I was running investigation for companies, the employee went straight to Fair Work, but Fair Work sent them back to the employer, basically telling them, have you actually followed the complaints and grievance policy procedures? And they would go, no, I don't know. Well, how about you just do that first? Then, if you're not happy with the outcome, you can come back to us. That's at least 2 cases that I remember from the top of my head where I had to run investigations following that process. In 2019, the Australian Council of Trade Unions conducted a survey, more than 10,000 Australian workers. They found that 23% of the respondents had experienced sexual harassment in the workplace in the past year alone. Now, there was an economic modeling that was conducted by Deloitte, my colleagues, estimated that the cost of workplace sexual harassment to the Australian economy was around $3.8 billion per year. That includes $2.6 billion in lost productivity and nearly $1 billion of other financial costs in 1 year alone. Now, there have been recent regulatory changes. On the 11th of September 2021, the Sex Discrimination and Fair Work Respect at Work Amendment Act 2021 took effect. Now, these amendments aim to protect workers and to empower them to address sexual harassment at work. On the 6th of March, the Fair Work Act stated that they expressly prohibit sexual harassment in connection with work. It doesn't mean to say that before they were happy with it, but it meant that the power was with the Australian Human Rights Commission to investigate matters relating to sexual harassment. Fair Work had the power to investigate and put a stop to bullying, but now they also have it for sexual harassment. A person or a company may be liable for sexual harassment committed by the employee or agent. Fair Work has the power to enforce a stop sexual harassment order and to investigate both individuals and organizations. Since the 12th of December 2023, the Human Rights Commission has the power to enforce compliance by organizations and businesses with the positive duty under the Sex Discrimination Act 1984. The positive duty, that's basically a legal obligation on organizations and businesses to take proactive and meaningful action to prevent relevant unlawful conduct from occurring in the workplace or in connection with work. Now, importantly, if the Human Rights Commission reasonably suspects that an employer or a person conducting business undertaking, PCBU, is not complying with their positive duty, they may conduct an investigation. Depending on the outcome of the investigation, they may then issue a compliance notice. They may recommend how to best comply with the positive duty. They may apply for a court order to enforce compliance and/or enter you into an enforceable undertaking. Now that is bad news, and we'll talk about it later. On the 10th of January 2024, SafeWork published a model code of practice relating to sexual and gender-based harassment, which needs to be applied in conjunction with the model code of practice for psychosocial hazard risk assessment. It is not a regulatory body. However, I would strongly urge you to read and follow these guidelines. Now, why is it so important for employers to really be careful and proactively prevent sexual harassment in connection with work? The first thing is because let's be human beings, good human beings, and we need to care for our people. So that's our primary duty. But also, an employer will be vicariously liable for the actions of their employee unless it took all reasonable steps to prevent the employee from doing the acts that constitute sexual harassment. Now, anti-discrimination laws, they don't provide a clear-cut definition of all reasonable steps, because what may be reasonable for a large corporation may not be reasonable for a small business. So instead, it's worked out on a case-by-case basis. The key point is that you must take active steps to minimize the risk that discrimination or harassment can create in your workplace. So when deciding what level of preventative action is reasonable, you need to consider the size, the structure available, the resources of your organization, the type, the nature of the work that is undertaken, the mix of employees in your workplace, women, young, older people, people with disabilities, people from culturally or linguistically diverse background, or LGBTQI+ community. The culture of your workplace. You need to look at also your previous incidents. And if you've had incidents relating to discrimination or harassment, have you actually looked again at your control measures so that you can prevent this from reoccurring? You need to look at your levels of employee supervision. When people are working remotely, do you have systems in place? But any other relevant factors, such as the working hours, the geographic isolation, the living arrangements, or duties which require working in close physical proximity with others. Now, let's look at a couple of court cases which significantly influence the way the law has been applied in relation to sexual harassment. There was a very famous court case, Leslie versus Graham in 2002. It was relating to out-of-hours, off-site sexual harassment. Now, the employer was found to be vicariously liable for the sexual harassment because the situation was that the harassment occurred between two employees in the early hours in the morning in a serviced apartment that they were sharing while attending a work-related conference. Now I'm quoting the judgment here. In relation to the particular facts of the case, Her Honor noted that the conduct occurred between two employees in accommodation provided by the employer as an incident of employment. Furthermore, the employees' rooms were in close proximity to each other, and they were accessible. And the circumstances created by the employer had allowed the incident to occur in the early hours of the morning. Finally, Her Honor noted that the second incident had occurred following a staff function at which Mr. Anderson, the perpetrator, had consumed alcohol that was provided by the employer. For all of these reasons, Her Honor accepted that Mr. Anderson's conduct on each occasion has occurred in connection with his employment. So even though you would not be aware of that, you're sending someone in good faith. Make sure that you have all provisions in place to anticipate that you give your employees, you send them an email, you give them instructions, You check if there is any risk associated with close proximity. These are the steps you need to take. There was another court case in 2023. The High Court was actually referring to the CCIG investment versus Shockman. It was about an after-work party. But this time, it overturned the decision of the Queensland Courts of Appeal, shedding light on when wrongful act occurs in the course of scope of an employee's employment. What it says is that consistently with the policy of the law, an employer should not be held liable for acts totally unconnected with the employment. In that particular case, the behavior of the employee was atrocious, appalling, and you would never, ever expect that from an employee. I'm not going to go into detail. If you want to look at it, go and see the court case. But clearly, that had nothing to do with work. Thus, it was not related to the workplace, no vicarious liability. Now, there was a very important court case as well. The Von Scholler versus Allen Taylor Company trading as borrowed timber. In 2011, there was a first case where the complainant took the company to court and said they are vicariously liable. The judge decided otherwise. The judge said, I decline to find that the employer is vicariously liable for the sexual harassment perpetrated by, and then the perpetrator. I find that developing the policy and conducting training sessions, the employer took all reasonable steps to prevent that from occurring. It took 9 years for this decision to be overturned. One of the actually incredible thing is that Fair Work lost the case. When I say lost the case, I don't mean they lost the case. They mean they lost the physical case with all the documentation and eventually found it 6 or 7 years later. So the case was reopened on appeal. And the new judge, and I'm quoting the judge because you will see how close it is to the amendment to the Fair Work Act on the 6th of March. The word all is significant. It is not enough for the employer to demonstrate that it took some of the reasonable steps available to prevent the employee from doing the unlawful act. So what you can see here is that the word all was the emphasis. There was some training, there were some policies, but there were flaws around them. So you really need to make sure that you take all reasonable steps to prevent. That's the other keyword here. Now we're going to talk about psychological safety. Sexual harassment is a psychosocial hazard. Now, psychological safety refers to a climate of mutual trust and a shared belief that it's okay to take risk. It's okay to express one's idea and concerns. It's okay to speak up with questions, but it's also okay to admit mistakes, all without fear of negative consequences. Now, a bit of history around the psychological safety. In May 2021, the Victorian government proposed new regulations that set out employers and other duty holders' obligation to manage risks posed by psychosocial hazards in the workplace. However, those regulations were delayed. A year later, Safe Work Australia issued its own regulations dealing with the subject matter. Now, they've been adopted by most states, but not Victoria, because Victoria cannot adopt the regulations because the OHS Act does not form part of the harmonized laws regarding occupational health and safety, which are the WHS Act 2011. So meanwhile, WorkSafe Victoria has established a specialist psychosocial inspectorate to investigate psychosocial hazards, and they've released information on the risk categories that are more likely to lead to a WorkSafe investigation and potential prosecutions. We'll go into detail of that a bit later, but what is important to know is that probably around December, hopefully, we're going to see new laws happening in Victoria. Now, what are the employer's obligations? As an employer, you must provide and maintain a healthy and safe working environment for your employees, including independent contractors, that is safe and without risk to their health so far as reasonably practical. You also have the obligation to prevent and eliminate sexual harassment in the workplace under equal opportunity and anti-discrimination laws. Last but not least, under the Fair Work Act 2009, remember that you must take all reasonable steps to prevent sexual harassment in connection with work. So we've got five laws here that you need to follow. The OHS Act 2004 in Victoria, WHS Act 2011 in the other states and territories, the Sex Discrimination Act 1984, the Fair Work Act 2009 and the amendments, and the Australian Human Rights Commission Act 1986. Now, why is it so important? Why is this now the talk of the day all the time, to talk about psychosocial hazards, psychological safety? Why is it critical? Well, it's always been critical first. This is not new. It's just more strongly enforced. But remember, it's always been in the OHS Act. It's always been in the WHS Act. There was a very famous Gallup survey in 2012. I don't know if you remember, but it was referring to the lack of employee engagement. And it was basically, the survey concluded that only 12% worldwide, 12% of employees were feeling engaged, and 24% were feeling actively disengaged. So all executives around the world, all business owners, they started to take actions. How can I get my employees to feel engaged and to feel happy? So well, let's put some ping pong tables and let's give them massages, and let's try to improve their sense of purpose and their pride at work. Nothing wrong with that. Totally value that. However, if you look at the pyramid here, it's called the hierarchy of needs, according to Maslow. Now, if you look at this, you cannot progress from the bottom all the way to the top unless you fulfill each of these needs. The basic needs, the very basic needs, that we need to be able to breathe. We need to drink water. We need to eat food and have shelter. Otherwise, we just die. That's pretty common sense. But the second one is the safety. If you don't feel safe, you cannot feel engaged. You cannot feel that you belong. So that level of safety is critical. That's why we must address it. Because it's not just physical safety. It's also psychological safety. So there are 14 different psychosocial hazards. I'm not going to go into the detail of them, but what you need to know is that there are aspects of work that have the potential to cause physical or psychological harm. For instance, to harm someone's mental health. On average, work-related psychological injuries have 5 times longer recovery times, much greater cost, and they require more time away from work. The hazards are more likely to attract attentions. They are the reports of aggression, high job demand, bullying, exposure to trauma, and or sexual harassment or gendered violence. Now, both short and long-term exposure to psychosocial hazards may cause harm to a person. For instance, if the exposure is severe, short-lived, and acute, now, for instance, such as experiencing violence at work, it may result in harm to health. For instance, you could end up with acute stress disorder or post-traumatic stress disorder. But it's also important to recognize that the cumulative effect of low-level exposure to psychosocial hazards can also lead to psychological or physical injury. For instance, if you combine a high job demand with poor support in an environment that is prone to conflict or poor workplace relationship, then the cumulative, whoa, that's a difficult word, that one, but the combination of these hazards will actually create the hazard, will create the risk, and will lead to potentially psychological or physical injury. Now, how do you assess psychosocial hazards? There are many things you can do. First, employee surveys. Employee surveys are not enough, but they're a good tool. They're a good tool because they will give you data to work on. They will give you evidence. They will give you information that sometimes employees will not give you unless it's anonymous. It will also give you trends and patterns. You can compare year after year and see how you improve. You need to run periodically workplace audits. And that's your safety audit. You need to analyze your incident reports. Every time there is a psychological injury and you have a report, look at the incident report and reassess your current corrective measures. Could you have prevented this? Is the question. It's not about the blame. It's about, could we as an organization do better to prevent this from reoccurring? To do that, you need to hold focus groups. So that could be your health and safety committee with your health and safety representatives. But what is really important, remember that health and safety, it starts from the ground and it builds its way up. That means you need to have consultative processes. You must conduct interviews with your staff. That's where it all starts. And then you run your psychosocial hazard risk assessment. Remember that a WorkSafe inspector, for instance, if they're calling the workplace following a complaint or a report of a psychosocial safety issue, they will look to see if the employer has a system to identify, assess, and control the risk posed by this psychosocial hazards. And if they have systems in place to review the control measures that are there. Now, the employers that have followed these steps are less likely to have a WorkSafe inspection turn into an investigation. Now, let's talk about hybrid working. Now, hybrid working is an interesting one. I've identified 4 key takeaways. First, there are a lot of mixed views. There are benefits, but also challenges. There are key considerations that you need to take. And what are the best next steps? So if we look at the mixed views, hybrid working continues to exist post-pandemic. We've all been through that. Everybody all of a sudden, apart from essential workers, had to work from home. However, since then, employers have mixed views on whether employees should return to the office full-time, part-time, or not at all. The government is actually investigating whether remote work should be a legal right. The Fair Work Commission in September began a review of the Modern Award, and they're going to examine whether the award should include a right for Australians to work from home. In addition, changes to the Fair Work Act will be introduced in 2024 in August, and they are the Closing Loopholes Amendment Act, and regarding the right to legally disconnect. Now that may create further challenges for employers in relation to their employees working from home. So what are the pros and cons from an employee, but also from an employer perspective when you consider hybrid working? Stating the obvious, from an employee point of view, it will improve the work-life balance. There is less burnout and fatigue because people don't have to travel. Sometimes people have got 2 or 3 hours of commuting. But also, let's not forget that people feel less connected to the organization's culture. The reason why is because if you remember, when we had COVID, we actually started to put a lot of different things in place. We didn't have a choice. Everybody was sent home. So we started to have little fun sessions on a Friday morning. We put systems in place, communication systems. But then, strangely, most organizations reverted to the old-fashioned way. Yet, some people are still working from home. So remember the good things that were done during COVID, and remember to apply them to your current situation with your employees working from home. Because what we find that there is a reduced cross-functional communication and collaboration. When you're not in the office, there is no incidental encounters between colleagues. When you walk past someone, you go, hey, by the way, how are you doing? That doesn't happen. When you hear conversations and you learn from that, new employees that learn a lot from hearing the conversations from their colleagues with their clients. Now that cannot happen because when you work from home, you have to actively press on a button and call a person. So there is a reality here that there is a little bit of a disconnect. But also, workers have to contend with potential heightened distrust from managers and employers. There is a myth and a belief that people from home don't work. I'm right now at work and I've not stopped since 8 a.m. That is not true. There are people who will abuse the system, that's right. But you just need to have systems in place to be able to monitor that and monitor their productivity. Rather than monitoring if they're at work all the time, it's what is the outcome. Now, from an employer point of view, there is a reduction in operational costs by having people at home. I know some businesses that completely stopped having an office or reduce the floor space. We don't need to have these huge offices anymore because we only have half of the people coming at any one time. There is also a potential broader workforce participation because caregivers, individuals with disabilities, they can work from home. So it opens up that workforce, which is fantastic. However, that also requires more investment in IT security, telecommunication equipment, structure, the equipment that you need to provide for your employees, the ergonomic chair, for instance. There's also communication challenges, either technological, but also interpersonal, and it requires a lot more systems to be in place to be able to monitor the productivity. So there is work to be done here. But remember that you also need to make sure that your employees are safe when they're at home. So you need to have a working from home or working remotely policy. You need to have your checklist to make sure that everything has been identified and that people at home are safe and also productive. Now, the key consideration that we need to remember is that it's not a one-size-fits-all. Hybrid working will require extra structure, extra intention, extra care. And yes, it is tiring, it is time-consuming. Its efficiency and effectiveness depends on multiple factors, including the employees themselves, the type of work that they're doing, the industry they work in, the culture, the existing culture and dynamic of the teams and organization. Now, working from home doesn't kill the culture. The culture was there. It was a good culture. It was not. If the good culture is there, then there is no reason why working from home will actually diminish that. Workplace is becoming a multi-generational space when we're seeing opposing views of where one should work. I've witnessed some real standoffs between employers and employees. Some refusing to go back to the office, some trying to force everybody to go back to the office. I think the key is flexibility and being adaptive. That's the key. If you are set in your ways, that's going to be very difficult conversations to have with employees. Many organizations are beginning to introduce policies where employees can work from anywhere, including abroad for a set period of time. Talking about, for instance, Meta or Facebook in Ireland, where actually people can work from anywhere in the world. The idea is to attract and retain the right talent and to allow for more flexibility and work-life balance. So the key takeaway is be flexible, be adaptable. Now, what is the next big step? First, make sure that you get the risk sorted. So you need to appropriately assess all individuals and organizational risk from workplace health and safety, from a security point of view, but also the productivity because it will create a commercial risk. Get the tone right. Ensure that there is transparency in your hybrid work policies. Be upfront with people. It has to be based on genuine trust. You need to empower your employees, but you need to make it very clear that they are accountable for delivering the work that is expected from them. So what system have you got in place to monitor that productivity level? Have effective communication systems. Be inclusive. What you don't want to create is a subculture that looks like the old smokers group. Remember the smokers group? Ah, yeah, they're out smoking again. Well, then you've got the people who work from home and the ones who never work from home. Well, you don't want to have subcultures. You don't want to have a divide. You need to be inclusive. You need to measure the impact. So if you're unsure, set up a trial period. Try it for 3 months. Let's see how it goes. But be very upfront with the employees that, hey guys, we're going to try for a little while. Manage the change effectively. That means you need to communicate early and regularly about any change to employees' working conditions. Now, we're going to talk about a subject that is a scary one. That's why I'm finishing with it. Underpayment. You will be navigating a real risk. So I'm going to start with a few definitions. Now, I'll tell you why it is relevant to talk about this, the complexity around it, and the risk associated with it. Now, in Australia, underpayments refer to a situation where an employee is paid less than they are legally entitled to under the relevant awards, agreements, the National Employment Standards, or set by the Fair Work Act 2009. Now, this can occur for various reasons, such as changes in regulation under the Fair Work Act. So, piece of advice, there is a button on the Fair Work website which sends you the newsletter all the time. Every time there is a change, you will receive that information. If you don't have time to read it, make sure someone does. Because I will repeat that later, but ignorance is no excuse in the eye of the law. You could have unintentional misses or errors, but sometimes you could also have negligence, human data entry error, but also the divide between payroll and HR duties, which is not clearly identified. Now remember, the job of payroll is you're giving me numbers, I'm processing these numbers, making sure the person is being paid according to the numbers you're giving me. That's not a payroll job to assess whether that job description is matching a classification under an award. That's an HR job. So if you're wearing both hats, HR and payroll, make sure that the right hand talks to the left hand. Make sure that you are trained on how to clearly identify what classification matches the job that the person is currently doing. Now, yes, it is complex. There's a lot of different things to take into account. Penalty rates, rosters, different shifts, public holidays, you name it, overtime. There are some awards that are more complicated than others. And I could mention, for instance, the SHADS award. Now, an unenforceable undertaking, that's the bad news. And unfortunately, as approved auditors by Fair Work, we review and audit enforceable undertakings, so the application of repayments. But it's too late. That means you've already got caught, and now you're going to have to face the music. Because it's a legally binding agreement between the Fair Work Ombudsman and someone who's not followed the workplace laws. So you contravene with the Fair Work Act. Now, it's different from a compliance notice. The compliance notice is like the first step. Sometimes Fair Work will find that there is an issue and they will give you a compliance notice. That means, please fix your acts, get that worked out, and we won't need to commence court proceeding. So it's a non-punitive mechanism. Now, you could also, as a board member, as a director, you could actually be found to be guilty of accessorial liability. Under Section 550 of the Fair Work Act, board members may be held accessorily liable for the contravention of a company where they were involved in the contravention. So what does that mean to be involved in the contravention? That means that generally you have intentionally participated in the conduct and have actual knowledge of the essential facts of the contravention. However, The participation is not limited to aiding, abating, counseling, procuring, inducing, or conspiring to commit the contravention. It could also just be an omission or a willful blindness. Now, the willful blindness is the dangerous part, because that means that you knew that something was happening, you did nothing about it and pretended that it was not happening. In essence, that's what willful blindness means. I'm going to refer you to the Fair Work Ombudsman versus Priority Matters, and what the Federal Circuit Court said. Where a person does not, because it does not want to know, where the substance of the things is borne in upon his mind with a conviction that full details or precise proofs may be dangerous, because they may embarrass his denials or compromise his protest. He has that knowledge, but deliberately refrains from asking questions or seeking further information in order to maintain a state of apparent ignorance. That is willful blindness. So, in another word, if you pretend that you did not know, if you just cover your eyes because you don't want to see the obvious, but you knew about it, you will be culpable of willful blindness. Now, the relevance. On the 1st of August 2023, that's not that long ago, that's just a year ago, the Fair Work Ombudsman reported that they recovered $509 million in unpaid wages and entitlement for more than 250,000 workers in the 2022-23 financial year alone. That's the second largest annual figure ever recorded in the Ombudsman history. Incredibly, though, over 50% of the errors came from universities and large corporate organizations with large HR, payroll, and compliance teams. Now, when you look at that, if these, like Commonwealth Bank of Australia, for instance, if these large corporations with dozens and dozens of people that are experts at what they do in HR, payroll, and compliance could not get it right, what chance do you have? Well, as a small or medium business, the only chance is just do a sample review. Make sure that all the time you check that you're okay. Because the investment in time or money, if you ask us to do that review for that matter, is nothing, is a fraction of the pain and the money you're going to get through if you get caught doing the wrong. Now, the reason why I'm saying this is because it's very complex. The system of awards, which set out minimum pay rates and conditions of employment, has undergone reforms and adjustments over and over and over. Now, these changes have typically been driven by legislative amendments, industrial relations reforms, and decisions by the relevant industrial relations bodies. In 1996, there were approximately 3,253 federal awards, but also a similar number of state awards. Now we only have 121 modern awards. That's aiming at providing a simplified and modern process to wage rates. It's still very complicated. It still needs training. Now, previously, business owners believed that if you paid above the award, the business would be simply compliant. Well, that's not true, because what they failed to consider was the complexity of the award system. When you're looking at basic wages, penalties, allowances, overtime. Now, that is the key. The key is that if you pay people above the award, you are not in a comfort zone. You need to make sure that annually you check that they are better off overall. You probably heard of the BOOT test, better off overall test. That means that if you were paying someone at the base rate and applying all the penalties, the overtime, the annual loading, and everything that is maybe taken off by the offset clause in the employment agreement, if you compare that with their actual pay, they should be better off at the moment. If they're not, you need to readjust. The danger is when you have agreements that are 10 years old and then people just forget about it. But remember, wages keep going up, the awards keep adjusting. You need to adjust accordingly. Now, today, employers will be facing allegations of underpayment frequently, and they will argue that the non-compliance was largely the result of the complexity of the award system. Now, the problem is there are two things to take into account there. One, we don't know what we don't know. Yeah, that's true. But if you say that to a judge, they will tell you again, ignorance is no excuse in the eye of the law. If you're an employer, you need to stay up to date with recent regulatory changes to ensure that your business remains compliant with the law, the awards, and Fair Work. Now, what is the risk? What happens when it goes wrong? Well, one of the key aspects of enforceable undertaking is that it is published. It is for everyone to see. I remember not long ago, we are working with an organization. Unfortunately, they've had some levels of underpayment. They're going through an underpayment. And I was looking for their address because we were just about to have an agreement with them to help them to do the audit. When I went on Google, although it's a very famous company that should be on, I don't know, dozens of pages for the right reason, but at the top of page 1, guess what was there? Enforceable undertaking. It had taken over every goodness and demolished it. Total reputational disaster. Now remember that if you have to self-disclose, now the Fair Work doesn't compel you to self-disclose. So if you see that you have some issues, that's why I'm always advising that have that sample review. And if you know that you have some problems, fix them. However, if you get caught, and that could be for any reason, it could be Fair Work knocking at the door, it could be an employee that is a bit disgruntled and calls Fair Work. Very often, employees that speak to the union and the union will just jump on the phone and straight away speak to Fair Work. Once you get caught, you will have the compliance notice that we talked about earlier, which is a non-binding. It's not a punishment. It's just, let's fix the problem. But it can also turn into an enforceable undertaking. Now, this enforceable undertaking, even if you self-disclose, you're not safe from being named and shamed. The reason why is because you might belong to an industry where the enforceable undertaking is going to be used as a deterrent to prevent the other businesses from doing the wrong and breaching their obligations. It's a very costly exercise, believe me, because we're doing it right now. And although we're working with a client, but really ultimately we're working with Fair Work. We have to conduct a review. So we have to review to make sure that all the payments are done properly and calculated properly. It took us 5 months for us to review. Can you imagine how long it took for them to just even create the repayments? Because it was historical over a long period of time, many, many years. Then we have to run 2 audits. A first audit where we have to go on site, and we're talking about northwest of Victoria, so you have to pay for the flight, you have to pay for the accommodation of 2 people, an HR and an audit, to go there and review on site, because we have to interview employees, which then again disrupt the whole business operation. And then we're going to have to do that again next year. That's how it works. So you can imagine the time, the amount of money that you have to actually devote to just fix the problem when initially a little bit of work, sample to make sure that you don't have the problem in the first place. And that's not talking about the penalties and the interest that are associated with it. Now, not following the law can lead to very serious penalties. Under the national wage theft legislation, the following penalties for a company could apply. If the court can determine the underpayment, the greater of 3 times the amount of the underpayment and 7.825 million. Or if the court cannot determine the underpayment, $7.825 million. For an individual, you're facing a maximum of 10 years in prison. And if they can determine the underpayment, the creator of 3 times the amount of the underpayment and 1.565 million. Or if the court cannot determine the underpayment, 1.565 million. Can you imagine? I don't know about you, but most businesses are just gone. And that's the wage theft. So it's really, really like the far end in terms of negligence, willful underpayment. But remember that it doesn't take much to underpay, even if it's not a wage theft, and you will still have severe consequences. So the best practice, with the passage of the proposed amendment of the Fair Work Act to criminalize breaches of that act, it is critical that owners, board members, take an active interest in the management of your company's financial affairs. So that includes investigating any complaints of wage non-compliant. Be on top of it right away. Reassure the employee, communicate timely and effectively that you are fixing the problem. It's always better to say, I have fixed the problem than I will fix the problem. Undertake training in Australian workplace laws. So if you have someone who's payroll and HR, make sure that they understand how to work with these industrial instruments, these awards, and maybe enterprise agreements, and commission regular HR payroll audits. We've got 10 minutes. Now, what I would like is, if you have some questions, can you please just write them down? And we are going to answer a few questions. Okay. Well, oh, Richard. Okay, I've got a big question here. Please make a clear distinction between psychological safety as a construct and psychological health and safety. They sound similar, but they are completely different. Oh, yeah, of course. Yes. Now, safety and health are two different things. Health is on a spectrum. So mental health is on a spectrum. And it doesn't mean that when you say psychological health, you can be very healthy, but you can also develop mental health conditions or mental illnesses. So there is a long spectrum here when you talk about psychological health. What we're talking about here is the psychological safety, as the feeling that you are free from harm psychologically. That's the distinction. But they are very different in terms of legal obligations. So thank you so much, Kate, for this comment. Now we have another question that was coming up. Now, if you have further questions, because when we send you the presentation, you may have questions that come to your mind. And please feel free to send us an email, ask questions, or to organize a time. For all attendees, I'm offering 20-minute conversation, confidential, to talk about any issues you may have specifically. So please feel free to take up this offer. Thank you so much. I really appreciate your time, and I look forward to speaking to you another time. Thank you, and bye-bye.